Today on Legally Us, Tiger Woods' ex wants NDA removed, Meghan Markle suffers a setback over her podcast, and Sedora's divorce gets messy as Giselle and Robin fire back at Eminem. We've got that plus so much more on today's Legally Us. Hey everyone, Christina Garibaldi here with Neama Rahmani, president of West Coast Trial Lawyers and former federal prosecutor. Neama, we have some big stories this week.
Hi, Christina. How are you?
I'm good. You know, this was a bit surprising. So we're going to kick it off with Tiger Woods. So a lot of people thought that they were still together, but it seems like he and his girlfriend, Erika Herman, have split after 6 years because she is taking him to court over an NDA that she claims he made her sign. And she's citing a law that prohibits NDAs when there's evidence of sexual assault or harassment. So she filed legal documents and she alleges that Tiger made her sign this NDA at the start of their relationship, which was around August of 2017. And she's now saying that that she is being wrongfully enforced on her, this NDA. So in the paperwork, she says a private trust that Tiger runs is attempting to keep her quiet about their relationship by aggressively enforcing the NDA she signed. She argues in her legal documents that the NDA should be declared unenforceable under the Federal Speak Out Act. She wants the judge to declare the NDA invalid and unenforceable. So before we get into it, what exactly is the Speak Out Act?
Yeah, Speak Out was something that was passed by Congress in response to really powerful men, people like Harvey Weinstein, trying to keep their victims silent. So they would enter into these non-disclosure agreements, settlement agreements that basically prohibited these victims, usually they were female, from speaking out. And that protected these rich and powerful men because women were unaware that other women had been victimized. And of course, that led to the Me Too movement. So this is something Congress did in response. So basically, these types of non-disclosure agreements with respect to sexual harassment and sexual assault, they're not enforceable. They're invalid. And that's why Erika is trying to have her particular NDA declared invalid.
Do you believe that this will be declared invalid? Does she have to come with, evidence of that she was, sexually harassed or assaulted or something like that?
Yeah, I think it will be declared invalid because that's what courts are doing, both at the federal level and at the state. And what's sort of interesting is usually it's sexual assault, which is, of course, rape or some sort of unconsensual sexual contact or sexual harassment. Now, sexual harassment, of course, requires some sort of employer-employee relationship usually. And of course, Erika started working at one of Tiger's restaurants. So it's going to be sort of interesting to see, is it one direction or another? Was she treated inappropriately as a female employee of Tiger Woods, or was there some non-consensual sexual contact while they were in a dating relationship, or maybe both?
Yikes. I mean, what do you think Tiger's move is going to be in all this?
Yeah, I mean, Tiger, the last thing he needs is some more bad press. He's obviously trying to recover from his bad car accident and get his career back on track. So this is not what he needs. Hopefully him and his ex can come to some sort of agreement to basically, again, there's no requirement that she not speak up. But I mean, certainly if something improper happened, Tiger's going to want to resolve that with Erika certainly well before it becomes public.
Right. Do you feel like she is looking for a settlement in something like this, or do you feel like she's just looking to maybe tell her story, or a little bit of both?
Yeah, it's tough to say. Sometimes these victims want compensation, but sometimes they really want to be heard, and they feel like them being silenced, that sort of contributes to the trauma, right? I mean, suffering silently is not easy, and there are victims, whether it's harassment or assault, that want to go forward, have their day in court, or be able to freely talk to the press and media, and that may be what Erika wants here.
Yeah, we'll have to wait and see. Well, speaking of messy couple situations, Real Housewives of Atlanta star Sedora, she lodged an explosive set of allegations against her estranged husband, Ralph Pittman, claiming in an amended divorce filing that he's a serial cheater, an adulterer. He abused her mentally, financially, one point got physically aggressive with her. So in her initial complaint, she filed as an uncontested divorce, simply stated that their marriage was broken. She is now, like I said, she simply cannot continue in the new amended complaint. She says that she cannot take his continued blatant disrespect and mental abuse any longer. She said that he repeated, like I said, a lot of adultery, and she's saying that he led her to have a reasonably justified apprehension for her emotional health and for the mental and emotional health of her children. They both want custody of their children. He is requesting joint legal and physical custody, while she has asked for joint legal but temporary and permanent primary physical custody per the documents. So why file an amended divorce filing so soon after the original filing?
Yeah, because I was sort of thinking about this and why someone would do that. So there's different states in the United States. Some are fault-based states and some are no fault. So when it comes to no fault, usually these types of allegations don't matter. And we know that Georgia is a no fault divorce state. But when I started digging a little bit deeper, even though it's a no fault state, you don't have to prove an affair or any type of adultery to file for a divorce. If there is some problematic conduct like adultery, it may affect, spousal support. So this might be something that she's trying to do to gain leverage in the divorce proceeding, but I don't think it's going to affect any type of custody arrangement. Usually there is a presumption of that joint physical legal custody.
No, that makes sense, because in her complaint, she says that that her ex should not be entitled to any alimony or spousal support from the repeated and condoned adultery. So it seems like, yeah, she does not want to pay up for him making a lot of mistakes, which I agree with. Why don't you think that she put this all in the first filing, though?
Yeah, sometimes you either don't want this to be aired publicly, you want to kind of keep your divorce private. I mean, we see this a lot, right? Whether it's, kind of Brad Pitt and Angelina, or, where celebrities really don't want to air their dirty laundry. But when it gets nasty and you go from a uncontested divorce to a really contested, nasty, bitter divorce, the gloves are going to come off and all that dirty laundry is going to come out. Those allegations are going to come out. And I think that's what we're seeing here.
Definitely. So based on what she outlined, do you think a judge will side in her favor? She won't have to pay the spousal support, the alimony, and will get what she wants in the custody agreement as well?
I don't think that adultery is going to, reduce the spousal support or alimony down to zero. It's a factor that the court can consider. It may sort of tilt the scales a little bit in her favor, but I don't expect a judge in a no-fault divorce state like Georgia to say, listen, someone committed an affair, someone cheated, therefore they're not entitled to any spousal support. It's just one of many factors.
Definitely. All right. Some more Housewives news. So Giselle Bryant and Robin Dixon, they are firing back against Eminem. We talked about this a couple of weeks ago, and this is their move to block their reasonably shady podcast trademark application. So according to court documents, they responded to Eminem's opposition of them moving forward and said that they were denied, that the Bravo stars denied they were on actual notice of Eminem's prior rights in the names and marks Slim Shady, Shady, and Shady Limited before adopting and seeking to register their name. They denied that Reasonably Shady is identical to Eminem's registered and prior use of Shady. They said their trademark would not confuse people, nor does it suggest Eminem had any role in their project. They're asking that the Patent and Trademark Office sign off on their application. Eminem said that it would cause some confusion, and he has not yet responded. But do you think that Robin and Giselle will get this trademark? Does Eminem own the name Shady?
I think Robin and Giselle have a very good argument. And the reason they keep talking about confusion is that's the legal standard. What is the likelihood of confusion? And, you talked about it because there's two issues. One is shady, right? Does Eminem own the right to shady anywhere and everywhere? Probably not, right? And this is something that's not shady, it's reasonably shady. Obviously, there's a distinction there. And then, when you're talking about that consumer likelihood of confusion, obviously, Eminem is a very successful artist. He's, had some successful films. He's done a lot, but I've never seen Eminem be a podcaster. And, folks, who are looking for what podcast to listen to, are confusing the Reasonably Shady podcast with something Eminem has. So I think they have a very good argument. There's not going to be confusion. This is a completely different genre of art. So if I had to put my money on it, I think the Patent and Trademark Office is going to side with the ladies on this one and not Eminem.
I don't want to be on Eminem's bad side, though. If they were to be denied, can they still keep that name? Would they have to maybe agree to pay him some sort of money to use the name, or would they come to some sort of agreement?
So if there's a dispute, there's actually a court that handles these types of cases. And it's an administrative court that really, where you sort of litigate these trademark disputes. So It starts at the attorney examiner level. If there's an issue, they'll ask if anyone objects to the use of the mark, and that's where sort of Eminem, we got his objection. If there's unable to come to a resolution, there's actually a group of judges that are going to have to decide this. It's not your typical judge and jury that we would see in a criminal or civil case, but there are actually judges that adjudicate these types of trademark disputes.
Interesting. Well, moving on to another trademark dispute. The United States Patent and Trademark Office has refused Meghan Markle's application to trademark the word archetypes. So in a non-final action filed on January 18th, the podcast production company Archwell Audio was informed that its application was being refused on the grounds that there was a likelihood of confusion with a trademark already in existence. She launched this podcast back in the spring of 2022, and she filed the application in March of 2022. The Patent and Trademark Office's initial refusal suggests that Meghan proposed trademark of archetypes is identical in appearance, sound, and meaning to one currently held by US-based Project Miracle IP Holdings. So now it's interesting. They can either extend this, pursue the application, extend, or abandon it. So what does that mean? If you're already rejected, why would you kind of extend this even further?
Yeah, so kind of going back, we're learning more about patents and trademarks and intellectual property than I've probably ever thought we'd know on this show. But so when it comes to trademarks, you submit your application to the Patent and Trademark Office. There's actually a lawyer, an attorney examiner that reviews it. So he or she will look at the mark and then look for the marks that are already registered with the Patent and Trademark Office and see, look, is there something similar here? If there is, they can reject it outright. They can ask for a response from the original owner of the trademark. And that seems to be what happened here. There's a substantially similar mark already in existence that's years old. So then the question is the owner of the mark, the original mark, are they going to enforce their rights? And if so, it's up to Meghan Markle and her team of lawyers to try to litigate it. And just like we talked about with Eminem, is it different? Is it substantially similar? Is there a likelihood of confusion? If they can kind of come to an agreement, great, then maybe both marks can coexist. And if not, that's when that litigation goes to that group of lawyers that actually hear these types of trademark disputes.
Got it. So it doesn't seem like the original archetype owner is really fighting this, though, right? As of right now.
They might not. And this is something we talked about during last week's show. I mean, if you have an intellectual property right, it's up to you to kind of enforce that right and police it. And if not, you've basically been deemed to abandon it, or people are going to use it. So it's very important for anyone who has that mark. If you want to kind of keep it, you got to tell the Patent and Trademark Office, no. You got to tell Meghan Markle and lawyers, no, cease and desist. All those letters that lawyers like to send. And then if there is no agreement, that's when the litigation ensues. But yeah, if the original owner of the mark doesn't respond or doesn't do anything, then Meghan's probably going to be able to proceed.
Kind of gonna be okay. All right, well, that is it for this week's episode of Legally Yes. Please keep commenting, keep subscribing, and Neama and I will see you next week. Bye.
Thanks, Christina. See you next week.
Thank you. For more news, content, and exclusive interviews, make sure to hit the sub, like, and bell button down below and visit usmagazine.com.